Hello, welcome to this masterclass on termination and construction contracts. My name is Paul Darling. I'm a barrister, Queen's Counsel. What I'm going to be doing today is discussing contractual termination and common law repudiation. I will be discussing the characteristics of both and the differences between each of them. Having done that, I will then identify some issues that arise in common law repudiation and the circumstances in which that remedy is available, and how somebody is able to avail themselves of that by bringing a contract to an end. Then, at the end, I will come to some issues that arise in relation to termination for convenience clauses, which is an increasingly important area. When courts construe termination clauses, they start by looking, I'm afraid, at the consequence, and they start from termination as a draconian remedy which brings the contract to an end with dramatic consequences. So over the years, the courts have evolved principles of construction to mean that people can't terminate contracts by accident. I think everyone used to think that a contractual termination clause made it very difficult for a whole number of reasons, to use the common law repudiation route to bring a contract to an end. The Court of Appeal has expressed a different view in a case called Stocznia, and has basically said that it needs clear words, essentially, to exclude the right to accept a repudiation at common law. The question is the breach so serious that it goes to the root of the contract? Now, I don't think that's a very helpful way of expressing it, even though it is the ancient common law exposition of it. Or the other way that I've heard it put is it reasonable to leave the wronged party to his claim in damages, or should he be allowed to bring the contract to an end? When one looks at all the cases, they're littered with things that prima facie look like repudiation, but in fact, when one gets down to them, are not common law repudiation, have been held by the courts not to be common law repudiation. The two areas that I think are most difficult in that area, which are of particular interest to construction contracts, are cases about delay and cases about non-payment of sums due under the contract. When you think something's repudiatory, look twice, and then look a third time. And if you still think it's repudiatory, look a fourth time. That doesn't mean that it doesn't happen. It obviously often does, but nevertheless, one shouldn't rush to find something to be repudiatory. One of the things about repudiation, and the cases on acceptance and affirmation and waiver are very much the pinnacle of this, is that you can find a case that says nearly anything. If one goes to Chitty and other textbooks like Keating and looks through the footnotes and reads the cases, you read 3 cases on the same topic and you think to yourself when you've done that, hang on, I'm not quite sure that they all point with the same voice. Termination for convenience, the general concept behind it is a party can choose to bring a contract to an end. Now, of course, like the termination clauses that I talked about a few minutes ago, they all turn upon their own words. Many people have suggested that you can only exercise a termination at convenience right, however it's expressed, if you're acting in good faith. I don't think that's right. More difficult is the suggestion that you can or can't give the work to somebody else in a construction contract. You terminate the contractor's contract for convenience because the new contractor down the road says he'll do it for 2/3 of the price. I'm quite clear that if the contract is silent as to your right to give the work to a third party, the courts would construe the contract as not permitting termination for convenience to give the work to somebody else. More difficult is if the contract expressly says that you can terminate for convenience so as to give the work to somebody else. I think the courts would, to be blunt, accept that. If the position is that this is a purely voluntary contract that you can perform if you like and not if you don't, that there is no, as it were, obligation, then there is a realistic argument that such contracts would be void for or unenforceable for lack of consideration. Termination for convenience clauses are not straightforward to enforce. Ultimately, I think that there are some weaknesses that can be exploited by clever argument, but overall, I think the likelihood is that as time goes on, courts will more and more easily give expression to the party's desire to have those sorts of termination clauses.